Good morning, everyone. Today I'm going to present my research on indigenous land rights, specifically looking at why legal recognition often fails to actually protect these rights in practice. My research compares two countries, Indonesia as the primary case study and Australia as a comparative example. Both countries have legally recognized indigenous land rights, but both still face serious problems in actually protecting indigenous communities. Okay. We move to the background and context. Let me start with some background for indigenous peoples around the world. And it's not just property, it's the foundation of their identity, cultural, spirituality, and survival. Indigenous communities have historical relationships with their land and that exist long before modern nation states were created. Today, international law increasingly recognize indigenous and land rights. The United Nations Declaration on the Rights of Indigenous People affirms this right. Many countries have put indigenous land rights into their constitution and laws, but here's the problem. Despite this legal recognition, indigenous communities still face land conflicts, displacement, and insecurity. This is the paradox that I am investigating. Let's move to the problem statement. So, what exactly is the problem? The central issue is this legal recognition does not automatically translate into actual protection. Indigenous communities continue to experience less dispossession, overlapping land claims, and exclusion from decision making about their own territories. This shows a fundamental weakness in contemporary land law systems. The problem systems from what I call structural disjunction between recognition and protection, formal or symbolic level, but the mechanisms needed to enforce those rights remain weak, fragmented, or difficult to access. In simple terms, governments say indigenous peoples have land rights, but they don't create uh, the system needed to actually protect those rights. Go to the methods. For this research, I use three main approaches. The first one is normative legal analysis, examining constitutional provisions, laws, and court decisions. Second, a case study of Indonesia, where I looked at how legal recognition works in practice with persistent and land conflicts. The third is comparative legal analysis with Australia, which uses a different model of recognition through courts rather than administrative procedures. This combination allowed me to identify patterns and structural weaknesses across different legal systems. We move to the Indonesian case study, legal framework. Now let's look at Indonesia. The Indonesia's legal framework actually provides strong formal recognition of indigenous land rights. Article 18B of the 1945 Constitution acknowledges customary law communities and their traditional rights. The basic agrarian law recognizes customary land rights as part of national land law. The Constitutional Court has made important decisions, such as ruling that customary forests are not state forests. So on paper, Indonesia has good legal protection, but what happens in practice? The reality is where we see the gap between recognition and protection in Indonesia. In Indonesia, recognition is conditional. It depends on verification and acknowledgement by local governments. This process is complex, inconsistent, and often influenced by political considerations. Many indigenous communities remain uh, unrecognized because of bureaucratic barriers, lack of documentation, or conflicting government interests. Even when the recognized customary land is largely excluded from the formal land registration system. This means indigenous territories remain vulnerable to overlapping claims and then concessions given to mining companies, plantation, or other commercial interests. To the structural limitation, the failure in Indonesia comes from two main structural problems. The first one is fragmented land governance. Different sectors like forestry, mining, and plantation are governed by different laws. These sectoral laws often override customary land rights. prioritizing state control and economic development. Second, administrative recognition enforces power imbalances. Recognition remains revocable and depends on state discretion. This doesn't redistribute authority over land governance. It preserves states' dominance. So recognition becomes a mechanism that can actually uh, perpetuate an indigenous vulnerability rather than protect them. Move to the Australian case study. Now let's turn to Australia, which uses a different approach. In Australia, indigenous standards are primarily protected through the doctrine of native title. This emerged when courts rejected the colonial idea of terra nullius, the false claim that Australia was empty land before colonization. Native title acknowledged that indigenous land rights survived colonization and can be recognized under Australian law, where traditional laws and customs continue to be observed. This is different from Indonesia because it provides a clearer legal pathway to courts rather than depending on administrative approval. Uh, Limitation of judicial recognition. However, Australia's system also has significant limitations. To claim native title, indigenous communities must prove continuous connection to land order under traditional laws and customs. This creates a very heavy evidentiary burden. Think about it. After centuries of displacement, forced relocation, and colonial disruption, how can communities prove unbroken connection to their land? Historical injustice make it nearly impossible to meet these requirements. Additionally, native people can be distinguished by various government actions, and even when recognized, native people often coexist with other rights, limiting indigenous control. So, while Australia offers stronger legal enforceability than Indonesia, judicial recognition still results in partial and conditional protection rather than full land security. And for the comparative analysis, when you compare Indonesia and Australia, we see different models but similar problems. Indonesia uses administrative recognition, which is flexible but weak and politically dependent. Australia is judicial recognition, which is more enforceable but has strict, strict requirements that exclude many communities. And both systems share a fundamental problem, centered land governance in both centuries. Indigenous land rights are acknowledged but subordinated to state interests, including sovereignty and economic development. This reveals the gap between connection and protection. Legal acknowledgement fails to offer underlying powers, relations over land. And for the conclusion, legal recognition is important and symbolically significant, but it does not automatically create national security. Both Indonesia and Australia demonstrate this gap for recognition to be effective. It must be accompanied by uh, develop enforceable legal mechanism, coherent land administration system, genuine participation of indigenous communities in land related decisions, institutional commitment to indigenous self-determination. Without these elements, recognition risks remaining symbolic rather than transformative. Effective land law reform requires a shift from formal acknowledgement toward substantive protection, ensuring indigenous peoples are not only recognized as right holders, but they are actually empowered to exercise their control over their traditional lands. Okay, thank you for your attention. I hope this lecture contributes to our understanding of why legal recognition often fails and what needs to change. The ultimate goal is not just to recognize indigenous land rights on paper, but to create legal system that genuinely protect and empower indigenous communities to govern their own territories. Okay, that's all from me. Assalamualaikum warahmatullahi wabarakatuh.